and just go over some stuff I highlighted from the defense opening. Let's see. One, he mentions they were all drinking. My sense was all the parties involved were drinking, including the 17-year-olds. Everybody's drunk. That can have a variety of implications, both favorable and unfavorable for the defense. One is if you're a defender and you're being aggressively approached by a number of people, there's a disparity of numbers, and they're drunk, people tend to act unreasonably when they're drunk. So that would escalate your perception of a possible threat here, especially given how easy it would be to drown in the river. Now, the prosecutor says, hey, the water's shallow here. At one point, they have the defendant face down towards the water, and they're shoving him towards the water. How much water you need to drown someone face down, especially if you have a bunch of people to hold them in place? Not much, right? There's all this talk about him having to walk away. He doesn't have to walk away. I mean, the whole question of retreat only comes up at the moment he's making the decision whether to imminently use force to defend himself. He's allowed on that river. They could shout at him for 20 minutes. We don't like you here, go away. They have no authority to order him away. It's not their property. He has a right to be there as much as them. He has no obligation to leave. Now, once he goes to use force, in that instant, might he be obliged to consider the reasonableness of retreat if it's safely possible? I would argue yes. That's the soft stand your ground aspect of Wisconsin law on the element of avoidance. But at that moment, when he's facing the imminent threat, when he's making the decision to defend himself, does he have a completely safe avenue of retreat? How fast can you move through water? He's 54. These kids are under 20. There's a lot of them. So I would argue that there isn't a safe avenue of retreat even then. And they're going hands-on with him at that point. How do you with complete safety retreat from a attack that's actually taking place? See, the boys were laughing. He says the boys were drunk. He takes the weapon out of his pocket well before he uses it, but he's not using it before there's an apparent imminent threat against him. The guy AJ is pushing the defendant face down in the water. The prosecution says the push doesn't do anything. Well, but you don't have to wait until you're drowned before you can defend yourself. You can defend yourself against the threat that's imminently about to happen. If they're apparently trying to push you into the water face down, that's relevant to your perception of an imminent deadly force threat. A prosecutor says no one, after they push him down, then they push him down face. So AJ is sliced in the stomach. Defendant goes down on his butt in water. No one pounces on him. No one tries to hit him. But all these people who stabbed him were stabbed because they were within arm's reach, which would also be consistent with him continuing to perceive this disparity of numbers attack. He's not chasing them down the river as they're running away. He doesn't walk away again, even though a couple of people have been stabbed now, I guess. And but again, in the midst of an attack, you don't have a duty to retreat, and it may well be not reasonable for you to attempt to retreat because you can't do it with complete safety in the midst of a fight. A lot of people, there's a delay. People didn't realize until a bit later that they were actually being stabbed. They thought they were being punched. I commented on that earlier. And in terms of the woman who was stabbed and the woman who was punched, the prosecutor wants to make a big deal out of the fact that they were women. But if there's a group acting in a coordinated manner to attack you, they're all responsible for the worst acts of the group. If two men are holding your arms and one guy's trying to stab you, they're all stabbing you. And you can use deadly force against any of them. So the fact that they were women doesn't matter if they could be reasonably perceived as an orchestrated attack by a large number of people on a single defender. The prosecutor mentions that some people in the defendant's group called 911, but he did not. Well, is he required to call 911, especially if he knows other people are calling 911? In fact, It's often advisable, if you're involved in a use of force event, for you not to call 911, for other people to call 911 on your behalf because of the things that you might say or not say on a 911 recording. If the purpose is to get police and medical there, and someone standing beside you is already calling 911, why would you need to call too? But having said all that, obviously the prosecutor is able and willing to talk about the fact that, oh yeah, other people were calling, but the defendant was not. Let's see. Some stuff that is not great for him is his conduct after the fight. Let's see. He gets up. I guess he's out of the river. He's up by the bridge. The police are looking for him based on that photo, and he's put on a jacket, a cap, and glasses. Well, I mean, that's not unlawful, but it could be characterized as consciousness of guilt evidence, that he's attempting to change his appearance based on what he looked like in the river, so it would be more difficult to identify him and hold him accountable legally. This is also true of when he throws a knife into the woods. Is that consistent with lawful self-defense, or is that consciousness of guilt evidence? That's tampering with evidence, right? Disposing of evidence. Even if your use of force was lawful, this is evidence that can be presented to the jury to suggest that you yourself believed it was unlawful. Otherwise, why would you do that? Then his interview with police. Of course, this is a train wreck for him. Again, I presume when we see this interview, we'll see there was no legal counsel with him. So just like we saw with the Alec Baldwin interview and the Hannah Gutierrez interview and many other interviews where suspects are Mirandized and then being interrogated by police, however politely, they bury themselves. They seriously damage. Also in the OnlyFans model case, which will be coming up, she did the same thing. Lengthy interview with the police, buried herself with her own interview. There are very few circumstances in which you should be talking to the police as a criminal suspect, and certainly not if they have Mirandized you. If they have Mirandized you, assert your rights. And there's generally no upside for you to be talking to investigators in particular without a lawyer present. And then he says a bunch of stuff in that interview. That's just harmful to him. Like he says he didn't have a knife. Well, we can see throughout these photos, he had a knife clipped to his pocket the entire time. He doesn't know where the knife went. He doesn't know where it is. Some of the stuff he's misdescribing, they took my snorkel, pulled my pants down. Could that just be his perceptions of what happened? Even of mistaken, reasonable mistakes about what happened? I think so. But the knife stuff is much more difficult to explain away. These claims that he took the knife off of some other person, how would you mistake that? I mean, if someone bumps into you and their hands are on your body, around your waist, maybe you think they're trying to pull your bathing suit down. Maybe just make an honest mistake. But how do you make a mistake about taking the knife from someone? Now, just because you're making those misstatements a fact, whether intentionally or not, afterwards, doesn't mean your use of force was unlawful. Your use of force could be completely lawful. And then during your interrogation, you say a bunch of stupid shit to try to, I don't know, talk your way out of trouble, you think? But what matters for self-defense purposes is not how you might have mischaracterized your use of force later. What matters for self-defense law purposes is, based on the actual facts as they occurred, was your use of force lawful? And that's about it. Let's see. And of course, by the way, everything the state says here in opening, none of it's evidence, right? So obviously much of this will be introduced as evidence later, but particularly the prosecutor's characterizations of things are part of his narrative of guilt to the jury. It's conclusions he wants the jury to go for, but that's not evidence, his characterizations of it. That's part of his storytelling.